SJR 105 is a proposed constitutional amendment, so we all know what the threshold of that would be. We'd have to get 2/3 vote on this side, and the other side then go to the voters on the November 2024 ballot. I'm just going to walk through the actual language that we have on SJR 105. We're hitting Section 9, Article 9 of the Idaho Constitution, which is compulsory attendance at school. And in your packet, I gave you a 6-page handout. It shows you what that has been. We adopted that in the Idaho Constitution originally as compulsory attendance at school. We've only amended it once because originally you only had to attend school 3 months out of the year, and that was the public schools. And then we changed it in 1972 with the constitutional amendment. So what we have today is there on SJR 105. I'm going to just walk through some key parts of the proposed amendment. The legislature may require by law that every child shall attend the public schools of the state. Now, where we do that by law currently is in your packet. It's on page 3, and it's section 33-202 of Idaho Code. We last amended that in 2009 with an amendment that passed unanimously in the Senate and the House. The language that we're putting into the Constitution now in Article 9, Section 9 very closely mirrors the statutory situation. So one thing I'd like to emphasize about this constitutional amendment is that it doesn't change anything that's happening in Idaho by law right now. It's the first thing. Okay, so let me dissect the language. First of all, when the legislature may require by law, of course, that gives us the option. So we wouldn't have to require that by law. We do currently in statute. We have a compulsory attendance law. Unless educated by other means, in Oklahoma, they're recognized to have a constitutional right to homeschool and private school because of that one part of their sentence, which is the same in Oklahoma, unless educated by other means. And at their constitutional convention in 1907, their delegates to the Constitutional Convention even talked about private school and private homeschooling. So when they later had a case at the Oklahoma Supreme Court, they went back to the notes of the Constitutional Convention and they said there is an explicit right in the Oklahoma Constitution just because of the unless educated by other means. As provided by law would be the statutory authorization to state what those other means are. However, the fact that we already have a may require, and Oklahoma does not have that as provided by law. And that was very specific of the Oklahoma Constitutional Convention to not include that so that it was clear by the delegate notes that they meant for there to be compulsory public education unless a parent or guardian adopted another means of educating their child. Because we already have that we may require by law, we don't need the as provided by law. So that's redundant. Custodial now are two sentences that we would be proposing to add are as follows, and they're really closely in parallel to statute right now, 33-202. It is custodial parents or guardians of any minor child in Idaho shall have the fundamental right to privately home educate such child or to cause such child to be privately educated. So that's just a statement, number one. And then those who privately home educate such children or cause such children to be privately educated shall be free from government regulation of such education, which means their private education. In other words, what they specifically teach, how they do it, how many hours, requirements, any regulation of the government of their private only portion, which means they're not partaking of any public education. They're not taking public funding for their private education. So private's very specific to mean no taxpayer dollars involved. What that does not mean is the following. If a parent is privately homeschooling or privately educating their child, and we don't regulate that space right now, because of the fact that we say unless educated by other means, we could still say there has to be some equivalency, so they have to be taught in certain subjects, which we currently have. We could add other equivalencies. And also, if they're partaking of any taxpayer funding, empowering parents grants, opportunity scholarships, if they're doing dual enrollment, if their kid is at a public school participating part-time at LPOSD in my district, we have a LPOSD homeschool, that is public. That is not private homeschooling. That's not private school. So that would still be subject to whatever requirements the government has on that part of their education. The advantage of adding this to the Constitution is as follows. In your packet, I kind of show you a top sheet that shows the history to tell you where we started, where we're going. When we first had revised statutes of the territory in 1887, and when we first adopted our Constitution, every student was required to attend public school. We didn't have any other option. Then we changed our compulsory school law in 1963, and at that time, we allowed local school boards to essentially do regulation. The parents had to check in with their local school boards. By the time we amended the compulsory statutes in 2009 unanimously here, the legislature had evolved to a position that we trust parents to privately home educate or privately educate their own children, and we don't regulate that space. And we don't have them check in with their local school districts. And so that's where we are today. By putting it in the Constitution, we're changing an implied right. So implied rights are things that are not necessarily in the Constitution explicitly, like the right to privacy. And the advantage of making an explicit right in the Constitution is that courts change over time. We redefine, like Griswold in the 1960s. If it's an implied right, it's subject to change in reinterpretation over time. So making it an explicit right has the advantage that it secures for future generations that this is a fundamental right. A constitutionally stated right is a fundamental right. Having something in the Constitution does not prevent some strict scrutiny government encroachments on that right. And that's why you see us have some encroachments on the right to free speech, the right to privacy, which is an implied right. But free speech is an explicit right. We have government encroachment under strict scrutiny on the Second Amendment. So just having it in the Constitution doesn't mean that the government has no say, but it changes the level of say to a strict scrutiny. And with that, Mr. Chairman, I think I'll stand for questions.